there's always going to be a legal industry, but it will become less and less relevant unless we change how we do what we do and what it costs people to have it done.
Today on Law Next, the first of a two-part in-depth interview with Jeffrey Carr, one of the most innovative general counsel ever, a man who describes his career as decades on the radical fringe of reforming legal services delivery. As general counsel at FMC Technologies in the early 2000s, he disrupted how legal departments hire and compensate outside counsel, creating models that today are considered standard operating procedure at many companies, but that were trailblazing at the time. After retiring from FMC in 2014, he went on to work with Valorum Law, the law firm that was one of the earliest to focus on bringing alternative fee arrangements to the mainstream, and which became the progenitor of the law firm Elevate Next, the affiliate of the global law company Elevate. He returned to a GC role in 2019 at Univar Solutions, where he sought to build the law department of the future. Now retired, he teaches, writes, and pursues his hobby of driving race cars. When we spoke, he had recently published a post on Bill Henderson's Legal Evolution blog called 4 Waves of Change in Law Land, and subtitled A Framework for Making the Legal Delivery System Better. Today, in part 1 of our interview, we'll talk about how Carr landed on the radical fringe of reforming legal services and discuss some of the initiatives he created at FMC, including the Alliance Counsel Engagement System, or ACES, a method of hiring outside counsel so unique that he was encouraged to patent it. But first, let me tell you about the sponsors who so generously support Law Next. Paradigm brings together 4 world-class legal software solutions to help legal professionals manage, automate, and grow their firm. With Practice Panther, Meriscase, Bill for Time, and HeadNote, lawyers have the tools to seamlessly operate all aspects of their firm in the office or on the go. Learn why more than 40,000 lawyers use its products at joinparadigm.com. Now on to the first part of my interview with Jeff Carr. Jeff Carr, welcome to Law Next.
Thank you, Bob. It's so great to be here.
It's great to talk to you, and we've been going back and forth a little bit on Twitter and email about getting this interview scheduled. And you told me just before we started, you told me this on Twitter also, that you are currently in your R330 status. I think you've retired more times than anybody I know. But what are you doing these days?
Oh, well, I'm racing cars and driving boats and tossing the occasional hand grenade into law land like I like to do. But I'm teaching a course at Southern University Law Center about really the business of law and the delivery of legal services as opposed to substantive law. Involved in a couple of other similar kinds of things. I've worked with LWOW, Law Without Walls, with IFLIT, the Institute for the Future of the Legal Practice, a couple of other things like that. So those are the kind of things that kind of keeping my hand in things these days.
Your LinkedIn profile currently lists your occupation as husband, race car driver, Manhattan mixologist, and legal revolutionary activist. Is that in order of importance?
Absolutely correct. And I should put father in there too. I mean, the husband, father would be absolutely the most important things. But yeah, racing is my passion. I really do enjoy that. I'm kind of a journeyman at it. I'm okay. I do some competitive amateur racing. And then I do what's called high performance driver education, which is track days, using a race car or even a street car on a track in a controlled environment. I do quite a bit of that.
Yeah. And this isn't something you just kind of came into late in life. You grew up around cars, right?
I did. Our family business was an auto body shop back in Dover, Delaware. And I worked in that starting at about the age 10, when I had a car before I was 16, a wrecked car that we rebuilt. And then I did some, when I was real young in my teens, I did some autocrossing and not competitive racing, but sort of the time trial type racing. Then I fell out of that in law school. between law school and married life kind of takes over. And I lost that. I was out of racing for a long, long time. Many, many years later in my career, I went to some corporate training event, and the off-site activity was an afternoon at a Bob Bondurant school in, I think, Phoenix. And I just found that, I still had a modicum of skills and I still enjoyed it. And then, as I do with most things, I get involved in it. And I get way too involved. At one point during my first retirement, I think I had 8 race cars at one point. I'm trying to be a little bit more rational these days in what I own and what I drive.
So do you still own race cars then?
Oh, yeah. Yeah, I do.
Are these, what kind of cars are these?
I've got a vintage Formula Ford 1969 car called, it's a little open wheel car. It weighs about 850 pounds, and at least until I get in it. And so it doesn't have a lot of power, but the power to weight ratio is quite good. And if you think about old school racing, old school Formula One racing, if you ever saw the movie Grand Prix, those are the kind of cars that I drive competitively. And they're just tremendously fun because it's kind of like a go-kart. There's nothing on the car. If it doesn't make it stop, go, or turn, there are no electronics, there are no ABS systems, there's no real safety gear other than a roll bar and a set of seat belts. So it's a very pure kind of competitive driving, and that's what I really enjoy. I then also drive late model Lotus sports cars, which I'm a pretty big guy. I'm about 6'2", 250, but like an idiot, I try to put myself in absolutely the smallest car cockpits possible. So it looks kind of stupid. It looks like a praying mantis getting out of these cars when I try to get out of them.
So this isn't like horse racing where jockeys need to be small.
Well, they don't really make cars for guys my size, and being smaller does help, particularly in competitive racing. A lot of times there are weight restrictions or weight limits where the car and driver have to weigh no more than X, or I'm sorry, at least X. And so for me, it's one of the reasons I don't drive something like Formula V, which are old Volkswagen engines. Because of their very low-powered cars, and I've got at least 100-pound weight disadvantage over most other drivers. So Formula Ford's a little better power-to-weight ratio for me, and the cars are inexpensive. They're inexpensive to maintain, so it's not like you're risking $100,000 or $500,000 on the track every time you go out on the track. These cars are not that expensive. So for me, it's a good combination of old technology, old school technology, skills. It's more about the driving and really just having fun.
Well, talking about old school technology, that may be just the transition we need to turn to some of the topics I wanted to talk about today. I could talk about auto racing for the next hour, but I don't think that's why people are going to listen to this podcast. Maybe it is. I don't know. But as I say, we've been kind of going back and forth about having you on this podcast for a couple of months now, and I'm glad we waited because in the interim, you just published this article recently, a blog post recently on Bill Henderson's Legal Evolution blog called 4 Waves of Change in Law Land, and subtitled A Framework for Making the Legal Delivery System Better. That may well serve as a good outline for some topics to talk about today. But one of the your opening sentences in that blog post is that you say, quote, "I've been doing this legal delivery thing for almost 40 years, albeit most of that time spent being pretty lonely out on the radical fringe." And I thought that was really interesting because I've been around long enough to know exactly what you mean there. I think a lot of people in the legal profession today may not even really appreciate how radical some of what you were doing was at the time. I mean, we are currently in a time, I guess maybe thankfully, that general counsel are talking about reforming the way they purchase and deliver legal services. But that wasn't being talked about when you started talking about that, right?
That's true. That's very true. And so I've seen a lot of change. It's not fast enough or far enough for me, but at least we're moving in the right direction as a profession, and as an industry.
I wondered that. I mean, as you say, you've been doing this for almost 40 years. How much change has there been? How far have we come? And how far do we still have to go?
Oh, wow. What a great question, Bob. I mean, some of my friends, especially those that were involved with me back in the ACC Value Challenge, which was in around the 2008 period or so, they say, Jeff, you're impatient. You complain too much about the pace of change. I think we're in this era right now where the last, say, 30 years, the change has been very small in terms of how the legal delivery system works. It's still bespoke. It's still largely dominated by either big law at the one end or then kind of solo practitioner, smaller law at the other end. So the change, the major change has been the dominance of big law. That I think we see that happening now. You look at some of the stats about where the numbers are, and it's astonishing how much of the market is taken by so-called big law, just in terms of revenue.
Yeah.
What that means to me, though, and my take on it is a little different than perhaps some, is that means that the consumer level, the small law, the small businesses, the individuals, even individuals with wealth, don't access the legal delivery system very much because it's too damn expensive. That's the part that hasn't changed in my view. I mean, I'll probably get this wrong statistically, but somebody once told me that the only cost that has gone up higher and faster than legal services is higher education. It's not medical, it's law. And you kind of look at that and you look at the way salaries have gone, particularly in big law. Not so much, of course, in smaller law, but I think the delivery system is pricing itself out of the scope and range of a normal consumer. I think that's the biggest change. It's also the biggest challenge because as GCs have become more parts of their business, I guess is the best way to say it, more involved with actually leadership within their companies, they're being forced more and more to do this, the classic more with less kind of talk. And so we've all talked about it for years and years and years. I think in the last, I don't know, maybe 5 years, 7 years, you see more people really doing more. My view, though, is that's still at the edges. We're possibly at the start of a hockey stick where efficiency starts to become more important, where it hasn't been, quite frankly, mostly because of the business model of the legal providers. The business model is still activity-based. And so to the extent they get pushback from buyers that have enough clout to say, I'm not going to pay that much, or I need you to focus more. But my sense is it's still a pretty incremental change, and there's a lot more to do. I think, I've been saying that we're at a tipping point for the last 15 years.
Yeah.
The question is, okay, I'll be right at some point. It's just, I don't know when.
Well, you can be right, and not everybody else be there with you.
True.
But a lot of the initiatives, probably for which you're best known, started were ones that you, I think, initiated while you were in your role as a senior vice president and general counsel at FMC Technologies,
right.
And before that, you had been assistant general counsel and worked in the corporate legal department at FMC Corporation, from which FMC Technologies spun out.
Right.
But where in before that you practiced law and did other things. But where along that career arc did you become radicalized? At what point did you land on the radical fringe? What brought you there?
What a great question. I mean, I think as I look back, my path was quite traditional from law school. It wasn't traditional getting to law school. I was going to be either a jazz pianist or a nuclear war theorist back in my college days. I ended up going to law school and doing the law review thing and clerking for a federal judge and going to big law and all that.
Georgetown,
kind of stuff.
Georgetown law, right?
Yeah, and it just was that very traditional kind of path for those that had done well in their first year of law school, or are they done well enough to get into a good law school? They did well in their first year of law school. And that sort of sets the path for everybody in law, or it did back in the 80s when I was doing this. I think the epiphany I had came from the difficult conversation I had at one of the firms, my last big law firm, where a partner walked into my office. I was about a fifth year associate, and we were the DC office of a New York firm. And I practiced in this really esoteric area of international trade law, which is anti-subsidy and anti-dumping work. Maybe 100 people in the world at that point did what I did and what our team did. And we were part of this big firm, but not really, because it wasn't one of the core practice areas of the firm. So anyway, the partner comes in and he says, Jeff, you really do good work and whatnot. But our practice group can only make one partner. We got 2 people in your class, and it's not going to be you. And that was one of those devastating conversations you have. You take somebody who's been successful by most measures all of their life, and all of a sudden you're being told, in my paradigm, you're not good enough. I thought that I hated the practice of law. And so I left the practice of law, and in a fit of idiocy, I started a company with 2 other guys, and we did international consulting in what was then called GATT, or WTO, World Trade Organization work, and then we also did privatization work. We were involved in the privatization of the Brazilian steel industry. We imported beer from a place in what was then Czechoslovakia. I mean, we did a lot of weird stuff. But what I did that for 5 years, and I say that period of my life was a period that I got my MBA. But I got my MBA by building a business, running a business, and running it right into the ground.
But you had also studied economics while you were in law school, right? Did I read that?
I had, and I was in Georgetown's joint degree program for foreign affairs as well when I was in law school. So that was always sort of a love of mine. But what I discovered during that 5-year period is I didn't hate the practice of law. I hated the business of law.
Yeah.
The way it had morphed in by the time of the late 80s, early 90s. So for me, this was 1993. Going back to a law firm was not something that I wanted to do in 1993. And I looked at working for the Commerce Department. I looked at going into the Navy and being a JAG lawyer. What I ended up with was I answered an ad in the Washington Legal Times that was looking for an international lawyer. And it was one of those weird things in your life where if you wrote an ad that said position desired, this ad was attorney wanted, and it was, it would have said the same thing that I said. Ended up getting a job going in-house at FMC. The weird thing about that job was, for me, I'd been a Washington lawyer, which isn't like a real lawyer. It's a completely different kind of legal work than what most people do. I go into a commercial setting, and I literally don't know anything about what these people are talking about. Business operations, contracts, representative agreements, distributor agreements, setting up a subsidiary in Greece, whatever it may be. So I did what every Washington lawyer does. For every question, I just picked up the phone. There's got to be somebody that has answered this before, rather than going to Westlaw or Lexis and doing deep research. No, you just pick up the phone. You try to find somebody who's done it before, and then you leverage their work. What I discovered in that epiphany was that in-house work was just like firm work. It was still being practiced one-on-one. And in a very individualized fashion. And that didn't make any sense to me. I mean, I remember the one of the first things I worked on was I needed to do a new international sales rep agreement. And I found within FMC, there were, 7 or 8 different forms of an agreement.
Yeah.
And that just didn't make any sense to me, because there wasn't any real difference between any of them. It was just individual lawyers. This was the way this is our form. This was what I like to use.
Right.
And so that was kind of what kicked off my thinking in terms of there's got to be easier, faster, better ways to do this, because it's not sophisticated work. I mean, it's important work, can be complicated, but it's just kind of basic blocking and tackling. Yeah. And that was what set me off. This was back in about 1993 on this path of really looking for efficiency and effectiveness, what came to be called in my lexicon delivered value, which was effectiveness, efficiency, and creating a great customer experience. So that's kind of where it started. And then it just, because we were a cost as the legal department in FMC, everything that I did was built with duct tape and baling wire, because there wasn't any money to invest in technology. There wasn't any money to hire consultants. And frankly, this stuff didn't exist back when I was working at it. And the story I tell there is we needed, after FMC Technologies had been spun off, might have been shortly before, but anyway, we needed a new matter management system because the system we were using had gone bankrupt and was no longer going to exist anymore. And as I was looking through the market, we ended up engaging what was then called Serengeti Tracker. And I remember a conversation with Don Murray, who was the president of it, and I'm talking to him and I said, Don, this looks great. You got a good e-billing platform. You've got a good matter management system that's kind of built out. But what I don't understand is this only deals with matters that are being handled by outside counsel. And, in my department, in my position, probably 2/3 of the work is internal. And I need to know status on that as much as I need to know on the outside. So why doesn't your stuff handle internal matters? And he looked at me and he said, because nobody's ever asked us for it. And that was an epiphany in and of itself. I mean, you had these systems that were being built up to manage outside counsel because that was really where the spend was. And it was this nascent sense of you should be handling matters and understanding what the matters are, but nobody was really thinking about what in-house counsel did, at least back then. So that, it kind of just, if you look at Tracker today, a lot of what they built, and it's now called Legal Tracker, a lot of it reflects inputs that we as a customer and some other of their initial customers had. It's much more robust, and there are a whole bunch of other offerings out there as well. But I mean, that whole area has changed significantly.
Well, Jeff Carr is best known for the innovations he developed while GC at FMC Technologies. He actually began developing his ideas while Assistant General Counsel at FMC Corporation, the company from which FMC Technologies spun off. When we return, we'll discuss how it came to be that Carr had his first opportunity to start shaking things up within a legal department. But first, let's hear about the sponsors who make this podcast possible. Busy lawyers want solutions that do the work for them in the background. Practice Panther is designed to help lawyers automate the mundane and time-consuming tasks that distract them from focusing on what matters, the law. The all-in-one platform offers a clean interface to manage your matters, track time, process e-payments, send documents for e-signature, and more. Learn why Practice Panther is the preferred solution for tens of thousands of lawyers at practicepanther.com. Welcome back to Law Next. In 1997, Jeff Carr was offered the opportunity to become Assistant General Counsel to an FMC business unit in Texas. But when he got there, he realized he had little control over the unit's legal spend. So he made a proposal to his general counsel. Give me more control over spend, and I won't take a salary. Just give me half of what I save. As we return to our conversation, Carr explains that some of the innovations he developed and is known for at FMC Technologies actually started earlier during this period when he was Assistant GC for FMC Corporation in Texas.
started when I came down to Texas to be the Associate General Counsel for what was then called the Energy, Transportation, and Equipment Group of FMC, basically the oil field equipment group, the food process, or the food processing group, and airline equipment group. And I was the only lawyer in Texas. Their stuff had been done out of Chicago. The business unit then wanted they wanted their own lawyer, but not really, because they really hated lawyers. And the general counsel at the time, I went to him and I said, look, I'm the international counsel. It was a new general counsel. And he was changing the way the work was done in the department. He was changing away from a series of specialists, kind of in a silo model, to more of a business unit specific model, or at least he was trying to do that. And we were getting rid of some people. And I said to him that, look, it looks to me like I don't have a job here anymore, as the international counsel. Why don't you send me to Texas and let me try that job? And his reaction was, interesting that you're asking me that. I've been watching you for a little while, and I need to send somebody down to Texas. I need a transplant that the body is not going to reject. And you're pretty good at smiling at people when you're telling them they can't do what they want to do. And so I went down there. I got down there, which was all great. But then I very quickly realized that I had absolutely no control over the vast majority of spend of that part of the business, because litigation was still being handled by an associate general counsel for litigation. IP was still being handled by an associate general counsel for IP. And while I was a business unit counsel and I could do counseling and whatnot, what they were screaming about was the high cost of legal. And I'm sitting there saying, you guys are spending X millions of dollars, and I control $300,000 to spend. I don't know what to tell you. So I went back to the GC and I said, I can't do this job. Unless I can handle and manage all of these other aspects, it's just ineffective. So I tell you what I want to do. I want you to let me have this area of work. I'll manage it. I'll oversee it. I'll get it done. And I don't want you to pay me a salary. I just want you to pay me 50% of what I save. And he puts his head down and he laughs and he says, I'd love to be able to do that, but HR won't let me. But I will, as an experiment, I'll let you have this control of this work. If you screw it up, it's your head. So that's how I sort of got the work. We then proceeded to get rid of most of our outside counsel. That was a period of time when the so-called ACEs model was first invented and developed.
ACEs is the Alliance Counsel Engagement System, right?
Exactly. It's basically a performance-based pay system. I hired my own people as I was building out the group, and I hired people that shared my philosophy on how we were going to deliver legal services. And then we started to perform. I mean, it took a while because a lot of the stuff is long lead time in terms of the payback. But the performance was there, the savings were there, the business unit was happier. They felt that they were being better served by the counsel that were embedded with them, and then we just kept building this stuff out. And like I say, I mean, it was duct tape and baling wire.
Explain what the ACEs system was. I mean, you really kind of targeted the traditional notion of the billable hour with that system.
Yeah. And so it's in its simplest form, it's just performance-based pay. It's a holdback of fees, and then at the end of the engagement, an assessment of performance, and then a payback of the holdback at 0 to 200%. That's kind of the basic model. Because we were lawyers, of course, we built a much more complicated model the first time around, and that was for litigation. And it's all math. I mean, it's not complicated, but I mean, you gotta those days you had to take a slide rule out to figure out some of this stuff. But it's in a spreadsheet, and it basically says we're going to divide a matter into 5 phases. And initially we started out with the 5 phases of a piece of litigation from, I don't even remember, maybe the UTBMS or something. And what we realized after a while, no, it's really time that matters, not whether this is the discovery phase or the dispositive motion phase. In each one of those phases, there's a target budget. We pay 80% of the fees during that time period. If the firm wants activity that would take them above that target, that's fine. They can do that. But now the holdback flips and it becomes 80% instead of 20%. As that holdback is building, depending upon what phase you're in, if the matter is concluded, settled, or tried, then there's an assessment of effectiveness. Was the objective of the client achieved or not? Based upon those two factors, time, what time period you're in, and what we used to call the deviation from expected value, there was then a multiplier applied to what was ever in the holdback. So if a matter was resolved very early on, the multiplier could be as much as 300%. As the matter went down to its last phase, the multiplier in its lowest sense would have been 125% if the objective was achieved. Although that could be reduced to below, you might get 0% of the holdback if you were so inefficient that you'd blown the budget. So that was the litigation model.
Yeah.
We then developed what we call the ACES Light model, which actually works for litigation or anything else. And it's much simpler. You simply say, all right, how are we going to do this? Billable hour, or fixed price, or some kind of a blend? Fine. What's our objective? That's the most important thing. What are we trying to achieve? Okay, start work. You bill us. We pay 80 cents on the dollar, 20% holdback. We're now going to give you a report card. And the system has now evolved to a simpler report card. It's just effectiveness, which is what was the customer's objective? Was it achieved or not? And that's assessed on a 1 to 5 scale, where 3 means meets requirement. The specific objective was achieved. Efficiency, what was the budget or the estimate? How'd you do against that? What was the actual? And then the third is experience, customer experience. How did we like working with you? In all 3 of those categories, the scale is 1 to 5. 3 means meets requirements. 1 means did not meet requirements. 5 means vastly exceeded requirements. And 2 and 4 are kind of plus or minus. What that system does is it forces the conversation that normally does not occur. And it's the conversation of the customer with the provider saying, this is my objective. This is my true objective. And don't talk to me. Let's make sure we understand what winning means in my context, because it may not be just a jury verdict. It may be paying no more than X. The second element then is the monetary aspect. I've told you what the objective is. You understand what the matter is. We need to come to a budget to this thing. Could be fixed price, but could just be a target. And then the third is, here are my service level expectations. This is the way I want to be communicated with. These are the kinds of things that I require you to do to report on the matter. Availability. These are what my expectations are. Things like that. I don't want a 50-page early case assessment. I want a decision tree, a 1-page decision tree. It's stuff like that. And then based on how that all gets done, you do the evaluation, and you're giving feedback now throughout. And based on that evaluation, you look at the holdback, and they get somewhere between 0 and 120% of the holdback. That's kind of the way 0 and 200% of the holdback.
Yeah.
On average, we paid our outside counsel 107% of their total invoiced amount. Yet over time, while I was at FMC Technologies, the company tripled in size. We went from a $1.8 billion company to about an $8 billion company. But our legal spend in that same period went from $14.8 million down to $9.8 million. Yet we paid the law firms more than what we billed. You can't do that. You can't pay your people, your providers more, and while the company is growing, and unless you change how you buy what you buy and what kinds of things you are doing. So, our litigation management went vastly down. Our counsel's performance went vastly up. The communication was tremendously improved. And what I like to say to the outside counsel was, we love you all. We want to pay you more for performance. But what we really want to do is we want to free up your inventory to sell it to other people. So it was a really interesting program. I still maintain that it's incredibly effective. It's something that everybody can use.
You patented it? Did you patent it, or did you try to patent it?
We sought a patent for it, and then we just abandoned it because, and we sought a patent because of all things, Tom Sager, a good friend of mine from DuPont, we're both old Delaware boys, I sketched this out to him, how this thing worked, on a cocktail napkin as we were sitting at an ACC annual meeting in San Diego. And he looked at me, and we were probably into our third drink by that point. And he said, "You got to patent this. I've never seen anything like this." And so we did. And then we just realized, first, FMC is not in the business of patenting. We're not in a legal service delivery business. Right. Yeah. And we were never going to make money from it. And that was never the intention. And so while it is still, FMC still technically owns the trademark, they don't use it anymore, and I have a perpetual royalty-free license to everything that's there, and so I just make it available to people.
Yeah. Apart from the billing side of that, this idea of this kind of values-based engagement, what's fascinating about that, I feel like I can't emphasize enough to some of the people listening today, was what you said about sitting down with the outside firm and having this conversation about what is our objective and how do we achieve that objective, because that was not typical in those days to have that conversation and to talk about what's the experience like, what is our experience like as a customer or as a consumer of these legal services. It was that the outside firm kind of came and told you what your objective was going to be and what it was going to cost you to get there, or some speculative amount for what it might cost you to get there, but they didn't talk about what was your objective.
Right? No, you didn't do that back then, and so my career's been long enough to live through this incredible change in the role of in-house counsel.
Well, and to help bring it about. I mean,
hopefully.
You've helped drive this change. That's what's significant here.
And it's for the good of the industry as a whole. I believe that I believe strongly in the profession, despite people often think that I'm just a grenade thrower. But I worry about it because I worry that if it continues on the current path, the customers will abandon it and they will find alternatives that suit their needs more. There's always going to be a legal industry, but it will become less and less relevant unless we change how we do what we do and what it costs people to have it done.
Yeah. In the next episode of Law Next, I'll continue my conversation with Jeff Carr. We'll talk about another of the initiatives for which he is known, the Litigation Value Challenge, which came to be emulated by the Association of Corporate Counsel and many of its members. And we'll also dive into his recent post at Bill Henderson's Legal Evolution blog called 4 Waves of Change in Lawland, in which he lays out a framework for making the legal delivery system better. Thoughts on today's show? Share them by tweeting us at LawNextPodcast. LawNext is produced, engineered, and edited by Populous Radio. I'm your host, Bob Ambrogi. I hope you'll join us again next time for another episode of Law Next.